we should start again. Maybe the others join then after this more or less boring topic about the limitation of liabilities. Is it on? Better now? Is it working? Is it working now? Okay. So limitation of liability. I think all those kind of mechanisms are known, actually. So we have a different mechanism to limit finally a liability of the seller for breaches in its representations and warranties. You could have a de minimis, which actually means that a claim resulting from a breach first has to exceed a certain threshold before it can be claimed. You could have a threshold, which means that the sum of claims exceeding the first stage, exceeding the de minimis, first have to reach a second hurdle before they can be claimed. And you may also have a basket, which means that again, you have a second hurdle of the sum of claims exceeding a de minimis before claims can be asserted. But if the hurdle is met, only the excess can be claimed, but not the amount that forms the basket. And cap finally means that the total amount of liability of seller under the SPA will be limited to a certain amount. And I would like to start here with France again and ask Axel, how often do you see these kind of mechanisms in your jurisdiction? Is it customary to have it? And is there a certain mechanism to calculate what the ultimate amounts would be?
So the answer is, of course, yes. We, in all the transactions, we see these mechanisms. The three of them, to be clear. Maybe the de minimis is not systematic. We would see it's maybe in half of cases, but the basket or threshold and the cap, I would say, is nearly systematical. I think the interesting discussion we had this morning when preparing shortly the meeting was the discussion on cap. It seems that there are some specificities in each country, so I will start by this. It's more statistics from the market and also from our firm, which I will deliver. So it's always cautious because, you know, anyone can have various practices. But to summarize, I would say that in France, we have a quite low general cap on indemnification. I would say that the general tendency we have seen is around 20 or 25% of the price as a general cap. And it seems that it's quite low compared to other jurisdictions. The thing is that the specificity we have is that this general cap is often excluded for certain specific representations. Where you had a different cap. So, for instance, tax. I said earlier that we use very few the tax indemnity. We rely on general representations and warranties for taxes, but we would have a specific cap for tax issues. Other than that, concerning the basket and threshold, we have the two concepts from the first euro or only in excess of a certain amount for indemnification. I would say that the amount, the general amount would differ depending on whether it's from the first euro or whether it's in excess. When we have a basket, we call it franchise under French law, where it's only in excess of a certain amount, it would be quite low, and the average would be around 1% of the purchase price. When it's what we call a threshold, meaning that you're getting indemnification from the first euro, usually in France you would have a higher amount, around 2 to 5% of the price. And then for the de minimis, it's not as usual as the first two concepts. We see it in half of the deals approximately, and the amount is usually quite low. It's below 0.1% usually. And the last thing which might be interesting to note about the French market is that what we have observed, at least in our experience, is complexification of all these mechanisms. They do exist in all deals, and so the tendency now is to, inside each item, to differentiate. As I was saying, for caps, for instance, you may have specific caps for specific indemnities. It's the same for the others. So we get quite complex clauses where you have an exception and you have specific thresholds for items.
Thanks a lot. And I will respond for Germany immediately because I think our both countries are pretty close. So at least if you're talking about the cap, we are in the same range. So mostly the cap in a transaction for general warranties are between 10 and 25%. Something in this range is usual. And it's usual to have an opening offer of the seller which is 10%. And but as in France as well, there are also a couple of warranties where there is a higher cap. So you would always have a 100% cap for a breach regarding representations and warranties regarding title and ownership in shares, of course. So this is the only thing, but here is also the common understanding. Nothing is uncapped. There will always be a cap to 100% of the purchase price on everything. One exemption is tax again. Tax and other indemnities are usually carved out. And then on the de minimis, and this is again same as in France, it's usually 0.1% or less, only in very exceptional cases, and this is about 10% of the deals that we are doing. We are beyond 0.5% for the de minimis. And on the threshold, here we are close to your basket rules in France. We are usually at 1% or less. So it's not that seller-friendly, I would say. But at least we are not seeing those kind of baskets any longer. We have seen this prior to the financial crisis. There it was a specific tool that was used in particular by private equity sellers, and it was very famous to request a basket. But now, even in a competitive auction process, sellers more and more decide not to request it in the first place and to focus the discussions on other points.
Just another issue. As for Germany, I forgot, of course, to mention, but it's important for title to shares, of course, in France, it would be also 100% of the price, but not more, which is important too, because in some jurisdictions, you have no cap for title to shares. In France, you would have 100% cap for this specific risk.
Thanks a lot. So how's this in South Korea?
Okay. Financial limits and time limits in indemnification clauses are very common in Korea. And Korean practice is similar to that of the United States. So many ask about Korean style or Gangnam style practices in indemnification. And the reason why we have a similar system as the United States is the supply side of the legal market. Most of the transaction lawyers in Korea are trained, educated in the United States. When they come back to Korea, they bring in the US practices. So the prevailing practice in Korea is quite common and it's similar to the United States. Let me start with the de minimis. Usually, de minimis is set at 0.1% to 0.2% of the total compensation. And threshold, it is usually between 1 or 2% of the threshold. It depends on the bargaining power of the parties and nature of the transactions, and also the size of the transactions. And cap, generally cap is set between 10 to 50%. And if the deal size is with $500 million US or more, generally the cap is set at 10%. Or if the medium small size deal, the cap would be increased to up to 75%. In some cases, the purchase price is at 100%. Likewise, France and Germany, tax and fundamental warranties, such as title ownership, are covered by the 100% purchase price. And as for the time limits, the practice is quite similar. As for taxes, usually it is covered throughout the statutory period of limitation. Generally in Korea, it is 5 years or 10 years in the case of tax fraud. And fundamental warranties is set 5 to 7 years. Sometimes the buyer wants the permanent indemnification for the title warranties. And all others, generally it is set within 2 or 3 years. And at least the warranty period, the indemnification period must cover the one audit cycles. And lastly, generally indemnity clauses exclude the indirect consequential damages or loss of profits. That's not covered by the indemnity clause in general in Korea. That's it.
Thanks a lot. It's amazing to hear that South Korea is so close to continental Europe. So how about the UK?
Amazingly enough, we're also quite close to continental Europe.
Oh, okay. Never noticed.
No, indeed. Broadly the same, apart possibly on the cap. So de minimis is a very general rule of thumb, 0.1% of the consideration, something like that. We would typically see a threshold more than a basket, so, and again, that would be set at around about 1% of the consideration. On the cap, it does vary. For the larger deals, I would agree that with the sorts of levels that you're talking about, in the mid-market, it's probably higher, and we're probably seeing caps at between 75 and 100% of the purchase price. Of course, there are exceptions to everything. If you've got a private equity seller, for a start, they're not going to be giving any warranties, and you're therefore faced with warranties being given by the management team, and there the caps will be much lower and will be referenced to a percentage of their net proceeds. But that's a whole different topic.
Okay, thanks a lot. How about Switzerland?
So any of these features are fairly standard to have in share purchase agreements. I've actually never seen an SPA without any of these. However, I would never go that far and say we have actually standard figures for de minimis, basket and cap. And I don't really like to hear in negotiation that something is a standard because it ties your hand a bit. Nevertheless, the minimis, what you see is between 0.1 but also up to 1%. Between threshold and baskets, more often you see actually threshold solutions instead of basket. Basket, as was said before, is something that came up with the private equity sellers. But I haven't seen any basket solutions recently. Cap, we tend to be a bit on the higher level here in Switzerland. I've seen 10%. I personally think it's extremely low. I mean, you buy something, you get reps, there's a violation, it meets the materiality threshold, not disclosed, and then you end up with 10%. It's honest.
Are you negotiating against that?
No, so in a nutshell, you can also, reasonably ask in a first draft for 20, 30%, even 50%, and obviously, what is much more valuable as a buyer to get the exceptions, which you typically receive for title, environment. Obviously, if you have gross negligence, willful deceit, and none of these limitations would apply. An indemnity, if you have a specific indemnity, which is typically the strongest means for a buyer in case of any breaches, whatever, then none of these limitations apply, not even the cap.
Okay, thanks a lot. And Alan, are there any statistics within Debevoise?
I think the practice varies, as others have said. I mean, broadly, I would say very similar approach to issues. Typically, you wouldn't have a limitation, for example, on title reps, and tax is quite often in the same category, although not always. In terms of the cap, as a buyer, you start, with 100%. As a seller, you probably start, 10, 20%. In most cases, you don't end up with 10, 20%. I mean, it depends a little bit on who the buyer is. I mean, if it's an international company, they're not going to be comfortable with 20% risk, 20% cap, and you're going to create some tension and get them maybe even nervous. If you're dealing with two Russian parties who know the business quite well, who can assess the risks, who have access to due diligence, then you actually might have a pretty small cap, but with some carve-outs for specifically identified risk areas or specifically identified risks. But I think if we were to do any type of statistics, I think we would still, on Russian deals, in terms of the cap, find ourselves something closer to the 50 to 100% range than to below 50% range. In terms of thresholds and baskets, also similar, and de minimis similar numbers, but they do vary depending on the deal size, especially deal size, because if you get sort of towards the $1 billion range, then you're obviously, you don't go with 1%, because that would be, I think, too high for not only for de minimis, but even for a threshold. But you also have to keep in mind, on the other hand, if the deal is smaller, you may have a higher threshold, because you have to be realistic that in those transactions, in many of those transactions, you have governing law, which is not Russian law, and arbitration outside of Russia, which is quite expensive. So if you're working on a smaller transaction, you don't just go by percentage. You have to be realistic that you're not going to go and arbitrate in London a $200,000 claim. So sometimes that can work as an argument to raise a little bit, the basket or the threshold.
Okay, thanks a lot. That's interesting, and I have to say that we once did a smaller transaction in the past and are now currently having an ICC arbitration process about 450,000 euro. This is really ridiculous, so the lawyers cost more than the claim. I would skip the next one in the interest of time, although it's also interesting, but I would like to pay more attention again to our last slide, and this is about the trends, country by country. So kinds of developments of where we think they are local, of local particularity. And with regard to South Korea, I would already like to ask Chongyang to also mention the earnest money again, because I found this a very interesting point. But now I would like to hand over to Axel in the first place.
Sure. I will start with the first issue, which refers a little bit to the one we had skipped, which is the payment security mechanisms. One of the tendencies we see from a practical point of view in France lately is the development of the warranty and indemnity insurance. This is, we have seen a lot of presentations from insurance companies for years and years, and we were listening at them with some curiosity, but actually had never, or in a limited amount, seen the insurance policies implemented. I must say that in the last 1 or 2 years, it's been implemented more and more in France, and even it's being discussed now very frequently. And even I was quite surprised in a recent deal with private equity funds that even from the start of the discussions at the level of the letter of intent, there were already some discussions on warranty and indemnity insurances. And we see this in France as a way of doing some deals which otherwise would be very complicated to negotiate. The typical example which I had on my recent deal in France was a company with shareholders which for various reasons could not give guarantees or very limited ones. We had private equity funds, which typically hate giving reps and warranties. And we had individuals which of course, who of course could not deliver the same amounts. And as the seller, we had a corporate group. And this is typically the kind of situation where a seller, being a corporate group, would need the reps and warranties, because it's, in France, it's the kind of things which would never go beyond the board approval if you don't have a classical set of reps and warranties. And so the insurance, the warranty and indemnity insurance would really facilitate the discussion and negotiations in these kind of particular circumstances. So clearly private equity funds, individuals. So it's both a means for the seller to avoid having a strong liability, potential liability on its balance sheet. And on the side of the purchaser, it's also a way to get some payment guarantees. If they have as sellers, companies with insufficient financial coverage, then the insurance mechanism would give them, it's a sort of payment security mechanism for some purchasers. So it's one of the trends which is very typical in France. I understand that it may also be the same in other countries. And it comes, as most of the discussions we had since this morning, it comes from the Anglo-Saxon practice. So in terms of how does it work in practice, there's nothing very specific for France compared to what you would have from the practice in the UK. Maybe, I don't know if you want me to switch directly to...
Yeah, sure.
Yeah, okay. Then the other tendency we have in France is we have seen it in recent deals, at least on our side, is the covenant to maintain employment. Since the financial crisis, and as you know, the employment rate in France is, the unemployment rate is particularly high. So I think it's something, this issue is one of the key elements for discussing, in particular on, of course, target companies, which are industrial companies and employing, of course, a significant number of persons. I would say that the issue is quite sensitive for various reasons. First of all, there are a certain number of companies in France where the French state would still have a minority stake. So these are private companies. I mean, there's no intervention of the state for the day-to-day management. But when it comes to selling the stake, in particular when the stake is held by some state by funds which are, controlled by the state, such as Fonds Stratégiques d'Investissement, that would be one of the things they would look at. Typically, in particular, if there are several purchasers, they would require purchaser to give to take specific covenants with respect to maintaining employment, and that would be a criteria for the choice of the purchaser. The other reason is local pressure. Some of these industrial companies are often very renowned in the various locations in France, and I have seen it in deals that the local pressure from the press, from the local administration can be very high and impose this type of covenants on the purchasers to maintain employment. And the third reason why we also see it increasingly is that that's another specific feature of doing business in France. When you're acquiring a French company, when there is a significant number of employees, you would need a prior consultation and advice of the Works Council. So it's of the works of the employees' representative. The Works Council is an employee representative, and it's very specific. They need to give their advice, and it's prior to signing any binding agreements. So even prior to signing the SPA, they need to give the advice, and it can be no, it can be yes, it can be a negative advice. You can still go to the transaction, but you need the advice. And what we see in the current distressed situation is that they are using every means they can, if they don't like the purchaser, to lengthen the process. So they cannot stop the acquisition, but they can, you know, make sure that it will take month and month, require some experts to be appointed and all this. And so in order to accelerate the process and be sure that the employees would give the advice rapidly, covenants to maintain employment would be a good way to make things happen more rapidly.
Thanks a lot. So next one on our list would be the UK. Simon, if you could pick out maybe the most important of your 3 points.
Absolutely. I mean, I think, my first two were going to be a general comment on the state of the market in the UK, and I think we've touched on quite a bit of what I was going to say earlier in this session. But just to pick out the headline points, we are beginning to see the return of a seller's market. It is a gradual process, but we have had some hotly contested sale processes which we've been seeing this year, mainly in the mid-market, I have to say, rather than at the top end of the market. Equally, we have finally seen the beginnings of an increase in distressed M&A. The UK banks, which have taken control of a lot of assets, are now, after a number of years, beginning to deal with those assets, and there have been a number of sale processes which we have seen, and fingers crossed that will continue. So then just to deal with the last point, which refers back to the public M&A arena, which I know we haven't touched on a great deal today. As you may well be aware, takeovers of UK public companies are governed by the City Code on takeovers and mergers. That's a set of rules that the UK panel on takeovers and mergers have set out. Those rules don't have statutory effect, but you can be subject as a bidder to significant fines or censure if you breach them, and so in practice everybody does comply with them. There were some fairly fundamental changes to those rules 18 months ago, which followed the hostile takeover by Kraft Foods of Cadbury, which is a UK chocolate maker. It was all very political at the time. We had elections on at the time, and it became a very political issue that the Americans were coming in and taking over English companies. And as a result of that, there were some changes that were made to the code, which everybody thought at the time might well have an effect on particularly overseas buyers coming in and making offers for public companies in the UK. In particular, bidders were given a period of 28 days, effectively, in order to do their due diligence. They were also subject to being named at the very beginning of an offer process, and up until that point, you could make an offer for a target company and not have your name in the public domain for a very long time during the process. So there was a reasonably significant concern that these changes were a bit of a knee-jerk reaction to political pressure. It would stop hostile bids, it would stop overseas investors, and it would stop private equity taking companies private. 18 months into these changes, well, we haven't had a huge amount of activity in order to road test these changes, but from what we have seen, I think some of those concerns are unfounded, or at least the impact hasn't been as great as people were fearing. It is clear from activity in 2012 that overseas buyers have not been put off making offers for public companies in the UK. I think there's one statistic out there of those deals over 100 million in value. In last year, 73% of the bidders were non-UK bidders. Equally, it hasn't completely shut out the hostile takeover process. Just to throw another statistic out there for what it's worth, again, looking at bids over 100 million in 2012, nearly 10% of offers were actually on a hostile basis. Now, don't take too much with that statistic, because the really one, it's not a huge sample size, but at least it does show that it isn't impossible for anything other than a recommended bid to take place. I think the jury is probably still out a bit on whether private equity have been shut out of making public offers. I mean, it was always very difficult for them, because the fee, it's a lot more expensive and uncertain to make, to take a company private than to do a bilateral negotiated deal. But one thing in particular is the 28-day period that private equity buyers now have effectively to do all of their due diligence. So I think the jury's still out on that one, but the impact on the other changes hasn't been quite as marked as was feared at the beginning.
Thanks a lot, Simon. So, Alex, what is the latest and greatest from the Swiss M&A market?
So the latest and greatest, I don't know if it's the greatest, but it is something which recently popped up a few times, and that's the reverse breakup fee. Reverse breakup fee is a feature in the share purchase agreement allowing the buyer to run away from the deal by paying a fee, which is, back in the 80s, it was seen in the US. Also, before the financial crisis, you had that, not maybe as a standard, but in many transactions, even in the public tender offer context, Google, Motorola, you had very high reverse breakup fee of several billion dollars. And now it comes in the private M&A context in Switzerland. And it's maybe nothing for, as Alan mentioned before, Russians who want to have a deal certainty, because obviously it is in the discretion, depending on the wording, but it's typically in the discretion of the buyer to use and seize this option to pay the fee, but not have to close the deal. And the background is as you may understand, is a financial point. Very often the buyer makes use of this option when he sees that the financial opportunities to finance a transaction has become either not possible or more expensive. And in that context, it may lead to the decision on the buyer's side to actually, after signing, not close the deal because he cannot afford it, but then has to pay the breakup fee. On the other side, on the seller side, you may think it's frustrating, but on the other side, it depends really on the fee, on the amount of the fee. And the figures that I've seen now are in the range of up to 10%, which is a quite significant number without getting anything and selling anything. It's just a breakup fee, which ultimately is something like an insurance for the seller. So that is something we will of course monitor more closely how the details of these clauses will look like and develop in the near future. But if you are involved in an M&A context, private M&A context involving Swiss parties, Swiss entities, don't be surprised to see something like a reverse breakup fee in the documentation.
It's an interesting concept, but actually it does not remedy the damage to the business as such, which is made to it by the announcement of the deal, which later on does not happen.
No, absolutely. I mean, it does not financially cover any damage that may happen, but on the other side, the seller may end up, having the reverse, the fee, and having the opportunity to sell it on to an next party, maybe.
If the asset is not burned, then. Yeah.
If the asset is not burned out, that's true.
Okay. Thanks a lot. On the German side, I would like to point out also here the business preservation covenants that we have heard already from France. And this is something that is really taken seriously by the German big corporates. So it's part of their good HR management to request from a potential buyer that the buyer commits towards the employees to certain covenants. This, let me give you one example. The first prominent deal, the first prominent direct investment of a Chinese state-owned company into Germany was the acquisition of Putzmeister a couple of years ago. And there the Chinese company undertook to maintain the terms and conditions of employment for a period of 10 years and not to close the location for such period of 10 years. And this really means something. And it's also part of the auction process that your bid is only competitive if you are willing to give such kind of undertakings. And I would now hand over to Chang Jung and ask him to tell us something about the earnest money.
Yeah, I'd like to first tell about how to deal with labor unions in the M&A context, and then I briefly talk about the honest money issues. First, when you do business in Korea, you have to think of two risk factors. One is North Korea, I already covered. Second one is labor union. Korea's labor density is 10% compared with 27% in UK. But still, Korea is somewhat notorious for labor union activities. Unions are organized company by company, but they are well organized in the manufacturing industry. And in the M&A, the unions tend to request a consolation money, so-called consolation money, from the seller. So seller has to pay some money from out of the purchase price, or have the company set aside specific accounts assigned for the consolation money. So it must be factored into the purchase price calculation. And usually the consolation money tend to be 2 to 3 months salary. Well, even in some extreme cases, it goes up to 6 months salary. So if you have a strong labor union in the target, you must factor in the consolation money in calculation of the purchase price. And second one is the job security request from the labor union. Like Frank's, unions are quite active and request the job security post-closing. And generally, the market standard is for the purchaser to provide a 3-year job security. No layoff, no cut-off, unless it is justified the law after the completion date. So one thing you should be careful is that buyer should not directly negotiate or contact the labor union prior to closing. If you commence any communication discussion, then it may be adverse to your exercise of right in indemnification clauses or invocation of MAC clauses. So until you get assured of the deal and the closing, and the buyer should not directly commence communication with the labor union. And I'll briefly talk about honest money deposit. It's quite unique in an auction deal, the M&As in Korea, sponsored by Korea Asset Management Corporation or Korea Development. These are all state-run government, quasi-government organizations. They generally control and oversee the procedure of sale of the distressed companies. And they usually push some kind of the honest money deposit scheme that protects the deal for the benefit of the seller. So it starts like this. The buyer must pay 5% of consideration at the time of execution of the memorandum of understanding. So 5% MOU execution. And additional 5% must be paid at the time of you execute the definitive execution agreement. So total 10% of the purchase price is put preliminary for the benefit of the seller. Generally, the money is put in the escrow account in the name of the seller. The buyer may sometimes have some security interest over their account in case if the money is returned to them. So at closing, the buyer is supposed to pay remaining 90% consideration to the seller. That's quite a pretty much established practice in an auction deal sponsored by the Korean state-run companies. And there is a big debate in the case of Daewoo Shipping and Marine case in 2008. The Hanwha Consortium won a preferred bidder status, and the deal value was $6 billion. They put up a 5% consideration, say $300 million upfront as an honest money deposit. And suddenly the financial crisis broke out, and the market collapsed. And Hanwha Group requested for the adjustment of the purchase price. And the Korea Development Bank refused. And they break out some dispute over the honest money deposit. They run up to the court, and the court's ruling is quite clear. The Hanwha Consortium, the buyer cannot invoke the MAC clause in this situation. So this is a really shock to the investing community. So when you do business in Korea, you should be, when you participate in an auction deal, you should be aware of this risk of losing honest money deposit when you depart the deal. This is a kind of prepaid reverse breakup fee scheme in Korea. There is no explicit breakup fee concept in Korea, but honest money deposit works for that kind of purpose. And that's the very interesting topic for Korean practice.
Thanks a lot, Chang-Yong. Interesting concept. We tried it once in a German deal, but did not manage to convince the bidders to actually pay the earnest money. Let's move on to our last country. It's Russia. Ellen, what is the main trend here at the moment? But not least.
Yes, exactly. Well, I surveyed my M&A team, and number one factor as a trend came up as increased role of state in M&A transactions. If, maybe 10 years ago, M&A practice was primarily driven by private parties, right now you see presence of state-owned companies, whether as acquirers or financiers of M&A transactions. And sometimes it's could be both, and sometimes the role could be changing. So you have the two state banks quite actively financing and willing to finance M&A deals until the state banks got active in this area. We really didn't have any leveraged M&A deals in Russia at all, because Western banks were not comfortable financing such transactions. But now Russian banks took that role, and they do it quite well. They can assess the risks. So you do have now in every other large transaction, you have some sort of financing element. And state companies are very actively consolidating. The trend now is towards consolidation in most industries, and the state companies are playing a very active role in that process.
Okay. Thanks a lot. Yeah, Maria, if you want to add something. Was the microphone for the auditorium? We also need it for my next question.
I completely agree with Ellen's statement again, and I just want to add something to the active role of the state-controlled enterprises in the M&A process. And having noted that trend, the government recently decided to regulate more how the M&A acquisitions should be approved within that state-controlled companies, because what was happened in relation to this biggest acquisition by Rosneft of TNK-BP is that the proper process was somehow avoided because the acquisition was made through the indirect subsidiaries. And currently, not long ago, probably in November 2012, there was an order passed by the government which provides that if an acquisition is planned through the indirect subsidiaries of the parent companies controlled by the government, then the position should be approved by the boards at the level of the parent companies, and the constitution of such parent companies should be amended in a way to allow the boards to approve that. And before getting that approval, the representative of the government should get clear position in that regard on each particular acquisition. Yeah.
Okay, thanks a lot. And then you can keep the microphone and hand it over to the next voluntary candidate. And this is my question to the auditorium. We are now at our last point of the first session. And the question is there anybody else in the auditorium who wants to report on certain trends in countries other than the ones that have been represented here on the panel? For example, Kazakhstan. Oh, there is a voluntary candidate over there. From Colibri.
Take me time to figure out. Okay. Representing Colibri that works in Kazakhstan and Central Asian countries. So basically, M&A deal is not a conventional deal in every particular industry. So it does vary dramatically from one industry to another. And for example, in Kazakhstan, one of the trends is actually if you practice in strategic industries like subsoil, then basically the government of Kazakhstan has the right to exercise the option of having a preemptive right to buy the shares of that are put on sale for example. This is what happened in a number of oil and gas transactions or in mining transactions. For other countries, even if the government doesn't have sufficient supply of cash to purchase the shares that are up for sale in a certain industries, then the government needs to have a final say on or approval, even if the relevant legal documents do not anticipate any approval requirements. So, in a sense, Kazakhstan and some of other stands in Central Asia, they follow in most trends that are more particular happening in Russia. In other words, the government takes over certain areas of industries. Well, it's kind of a deprivatization. Another trend, for example, in Kyrgyzstan is that because of the revolution that happened and that ousted the former president, the government is undertaking to deprivatize the assets and again put them on sale. In certain instances, these assets are toxic for many large-scale corporations that operate globally. So, but these countries attract Chinese investors, for example, that are not that, I would say, cautious about toxic assets. So, in a sense, the trend is basically the same. You see lots of involvement of government into those transactions, but the motive is rather different. They would like to control the so-called strategic industries, and who are the players there. For example, in banking sector in Uzbekistan, you don't have foreign banks playing a significant role, except for Korean banks that are pretty much welcome. For example, Chinese banks or Russian banks are not welcome. It's not written in the law, it's not written in the contract, but there is something else in those countries that dictate the rules of game, and this is probably some sort of political understanding. Thank you.
You need to know this when you are doing a deal then in Kazakhstan or Kyrgyzstan, yeah?
Yes, for sure, but many players who are already on the ground, they admit these understandings, they know the rules.
Okay, that's fine. Thanks a lot. So is there any other representative of any other region here in the room who wants to comment on our last point? Because if not, then we change now to session 2. Thanks a lot for your attention for the first part. We will change the seating order now, and in parallel, I would like to ask the technician to put on Maria's presentation now. So we have had prepared some backup material, but this will be saved now for the next year. So I would ask Ellen to change seat with Alexander, and I would ask Simon and Chang Yun to change seat with Maria and Valerie, and somebody else from the organization team to change the name signs. And then we have a running change. Say 15 to 20 minutes. I think we can exceed a bit. We have a bit time delay. And for those who are leaving, I would just remind you, if you want to have the presentation also with some substance behind it, then you can leave your business card or hand them over to us. Later on, there is some kind of a box at the exit where you could leave it. Okay, and in this complete mess, I would like to welcome now Maria for her presentation on a very specific topic, which is about the question whether a deal under Russian law can be structured according to the international standards that we have heard in part 1 of our session. I think I have this. Oh, you want it?
For the benefit of this audience, I would like to continue discussion of the structuring points regarding Russia-related M&A deals. And basically, the first thing I would like the audience to focus on upcoming amendments of the Civil Code of the Russian Federation, which will greatly affect the corporate transactions and M&A deals in Russia. Basically, it was initial plan that the entire bundle of amendments would come into force by the 1st of September 2012, but even though the entire bundle was approved in the first in the first reading of the parliament, it didn't happen for the reason that the amount of amendments is really huge, and at the end of the year amendments were split in parts, and basically 2 of the laws have already been passed. One relates to the general provisions of the Civil Code, and the law was passed at the end of the year and came in force from the 1st of March. And the second one, it's a fresh one, which was passed just between the May holidays break on the 7th of May. And most of the amendments will come into force on the 1st of September 2013. The second part actually relates to the rules on invalidation of the transactions and rules governing powers of attorneys. 2 major parts which will greatly affect M&A deals. The part on corporations and the amendments on contracts are still pending, but it is expected that at least the chapter 4, which governs law on corporations, will be considered by the parliament before the summer break. But it's not that clear when the amendments on contracts will be finally passed. The tricky thing in Russia, though, is that even if you have the positive law in place, which is in accordance with international standards, it would not guarantee that the Russian courts would apply this law consistently. And it could be quite... it could be shown by one example what happened with the shareholders' agreements, which were legalized about 4 years ago. But recently, the court practice turned out in the way to limit the freedom of shareholders' agreements, and in particular in relation to the possibility to refer the disputes arising out of a shareholders' agreement. The Supreme Arbitration Court recently ruled that those type of disputes are not arbitrable. But there is a hope between practitioners that this position will change, but currently it's what we face. Shifting to the particular points related to M&A transactions, I would firstly stop on representations and warranties, probably in the brief fashion, because it was already been discussed. But I would like to draw your attention to the fact that in many European civil law countries, the concept of warranties with regard to shares was developed by extension of the concept on the warranties with regard to the quality of goods. But it is unlikely that Russia will follow this route, because the rules on the warranties applicable to the quality of goods, they were designed basically for consumer contracts and B2B transactions in trading. And therefore, this approach that you could qualify the warranties in relation to shares, does not have great support by the Russian courts at the moment, which basically say that reduction of value of the company does not necessarily mean that the purchase price of the shares shall be accordingly reduced. It does not mean, however, that you cannot put into a contract a mechanism that would allow you to adjust the purchase price, because generally it is allowed by the express provisions of the civil court. But here you would need to be careful, and the position would be pretty much the same as in France, that the parties could be under the risk, and basically that would be the risk of the purchaser, that the court will found that the price adjustment mechanism was not put in the proper detail, and so the parties basically did not agree on the price. So there is a room for improvement, and basically amendments are now considered and include introduction, representations and warranties and indemnity concepts into Russian law, but in quite strange manner, because you need to understand the legislators. It's absolutely right what Ellen said, that each law in Russia has its own view how it should be implemented. And the problem is that somehow the common law concepts should be adjusted to, shall be put into the civil laws. And what we have at the moment is that the legislator tend to interpret the warranties more like representations in English law. And basically what will be required for the claimant to prove is that, and basically we assume that the claimant could be the purchaser, that the purchaser reasonably relied on certain statements made by the seller. And in absence of accuracy of that statements, it really does not want to proceed to the completion. But the other thing which is not typical for the English law concept is that the claimant would also need to prove that a seller was aware that the purchaser relied on certain statements. So as you could see, the concept is still developing, and it is now no clear understanding what we will have at the end as a positive law. The other question, which was not covered by the previous discussion, is to a certain extent it was covered, is conditions precedent and their use in Russia-related deals. And here I would like to state that in general, conditions precedent and conditions subsequent are allowed under Russian law. But the concept is narrowed down only to the conditions that are not within the control of the parties. At least it's what the leading court practice now say. And what is the solution currently proposed by the civil court amendments? The way is not to change the concept in relation to the transactions as a whole, but to allow expressly separate obligations which will be conditional on so-called potestative conditions that could be dependent, fully dependent on the actions of one of the parties to the deal. And that shall solve the existing problem. The other problem, I believe that it's more technical one, but it's what we currently face, because limited liability companies used to be a quite commonly used joint holding structure for joint ventures in Russia. because registration of the share issue is not required and there is no strict requirement as regards disclosure. But what we had recently at the end of 2008, the law was amended with the target to provide protection from green mail, and it was provided that the share transfer shall be certified by the notary public. What does it mean in application to the conditions precedent? It means that the parties which include now the conditions precedent in the contract relevant to participation share in a limited liability company are under the risk that those provisions will not be valid because the transaction requires certification by the notary, but once it's certified, then the share is deemed transferred. That's the collision that we have at the moment. The other topic that I would also like to discuss is whether in Russia we could apply completion mechanism which are adequate to international standards. When a foreign investor comes to the Russian market, it expects that it would be able to apply the mechanism of escrow arrangements. And the question is whether it is available in Russia, and the simple answer is not at the moment, but the position would likely to change if the amendments to the Civil Code are finally approved. However, I would like to draw your attention to the fact that even though we don't have similar concepts as escrow arrangements in Russia at the moment, we could use analogous mechanism which at least allow to complete the deal within 1 day. We tested that with a couple of banks, and the first option is to involve the international bank having a local office in Russia, and the condition to that is that seller and buyer shall open custodian accounts with the same local bank which acts as a custodian for the deal, and at the same time the purchaser opens an escrow account with an international branch of the bank, and then two offices or two branches of the bank, basically two subsidiaries of the international bank, they act on the basis of coordination agreement and to procure that the completion happens within 1 banking day. We tried that option with ING Bank and Raiffeisen Bank, and it was successful. The other option now proposed by the local banks, such as Gazprom Bank or Rosbank, is so-called services delivery versus payment. It's executed based on the agreement that shall be entered between a seller, buyer, and the bank. And one bank acts as a custodian for both parties, so both parties shall open a custodian account with the local bank and then bank accounts. The must-have for this structure to work is that both parties on completion date by certain deadline shall file the transfer orders to the bank so that bank could complete the transfer of shares and the money within 1 operational day. The other important question that is asked to us on the number of instances when a foreign investor looking forward to make an acquisition in Russia is whether it could have a fair exit at some point, probably upon satisfaction of certain conditions. The straightforward answer in relation to limited liability companies would be that, yes, we have an instrument when the participant or shareholder of a limited liability company could simply put share to the company if such mechanism is provided by the constitution of the company. But the problem is that the process is over-regulated and formalized, and there is no option in setting up a price, and such buyback by the company shall be per net assets value, which is defined based on the annual accounts of the preceding year, and the payment could only be made by the difference between net assets, pro-rata net assets portion value and the share capital value, which means that if the net assets position is bad and the net assets are lower than minimum share capital, the exit will not happen. In that case, the company is restricted to pay anything to the exiting shareholder, which means that he shall be reinstated as a shareholder within the company, and there is no exit in the end. The other important issue is whether classical options, put and call options, drag and tag alongs, whether they work in application to corporate governance structures in Russia. In relation to the capital markets, applicability of option has already been recognized by a number of laws, but in relation to the corporate governance, it is not still clear. We have some direct indirect indications, and the corporate law says amended to the moment that options are possible. But the court practice is still confusing in that regard, and probably amendments to the civil code will help to change that position. The great issue now is that it is exactly the point where the legislators could not agree in the moment which way to go, and the underlying concept of the option agreements in Russia is not clear. And at least it is not followed the international standards. Getting back to shareholders' agreements, I would need to say that even though there is a positive regulation in that regard, there are still many open issues. And the basic issue is how extensive could be the scope of the shareholders' agreement and to what extent it could be enforceable. With regard to the shareholders. And therefore, the application of shareholders' agreement under Russian law is still very uncommon. And the basic structure for the joint ventures, which is still widely used, is that a holding company is established outside Russia, and then it gets 100% shares in a Russian operational company, and therefore a shareholders' agreement is entered into at the offshore level rather than under Russian laws. And the question is whether that structure sort of solves all the problems. And I would need to say that the answer is negative because, and particularly if you make a deal with a Russian partner, a Russian shareholder, because in that case, a foreign investor could find himself in the Russian court, and there is no certainty how the court would apply the provisions of offshore shareholders agreement. The other problem regarding this offshore shareholders agreement is that a foreign investor being a direct shareholder of a foreign holding company has no direct claim to the management of the target operational company. And that's really a big deal in Russia because by operation of law, the general management, basically the general manager of a Russian target company has very broad powers to bind the company in relation to the third parties. Well, the question is whether the amendments to the civil code would help to resolve that. I would say that to a certain extent, but let's see, because the wording is still changing. But the latest problem that the practitioners faced in relation to the shareholders agreement is that at the beginning of the last year, the Supreme Arbitration Court ruled that agreements which looks like shareholders agreement are not arbitrable, and the disputes arising out of shareholders agreements are corporate disputes and subject to exclusive competence of the state arbitration court at the location of the target company. But some of the practitioners still believe that the position could change in line with the recent Constitutional Court ruling with regard to real estate transactions, because it was a position of the Constitutional Court expressed in relation to real estate transactions that they may be arbitrable. So there is still room for discussion. Just to conclude, I would need to tell that still the indirect acquisition structure that allowed to apply foreign law is very popular in Russia, and most of the deals are not made under Russian law, unless the party is forced to apply the Russian law, which sometimes happens with the state corporations like Rosnano. This means that the availability of expertise in English law is really an important point to be competitive in the market of legal services. But with the trend that the legal environment in Russia is becoming more and more complex, I would say that the trend is more that you shall not only have good expertise in English law, but should have profound expertise in Russian law to act in the best interest of the client and to follow the deal up to successful completion. Thank you very much for your attention. That's actually all.
Thanks a lot, Maria. Let's assume Russian law would implement all options that are currently available under other jurisdictions. Do you think that is then realistic that more and more also cross-border deals will be made subject to Russian law?
At least it would, is expected to be encouraged within next several years after the amendments to the law are passed. But I still think that it will take a long time for the Russian courts to form a consistent practice of application of these new laws.
Okay, thanks a lot. Maybe one comment from our experience on the German market, where also foreign investors sometimes feel reluctant to go to the state courts. So I would say in about 80%, 85% of all cases, we end up with an arbitration clause. So I would think even if this would be possible at Russian, this would help a lot.
Yeah, I think so.
Okay, any other comment from the auditorium before we move on to public M&A? Okay, that's not the case. Then thanks a lot, Maria. And I would like to hand over to Alan, and he will report on certain improvement potential under Russian public M&A. Yes, of course. And I would like to ask the technicians to put Alan's presentation on the screen.
I actually prepared my presentation in Russian, but I don't know if you want me to continue in English or
feel free.
in Russian.
Try to follow.
Yeah, okay, maybe we switch to Russian. I hope everyone has, if anyone needs the translation, please take earpieces. Я хотел бы
I would like to, in my presentation, to dwell on some aspects of the market development of the M&A, public M&A deals, then briefly looked at the main options of acquisitions of public companies, but taking into account the limited time that we have, I would like to focus on the issues of improvement of Russian legislation in the field of public M&A, especially in the light of the international experience, and taking into account that at this forum we have a brilliant opportunity to discuss these possibilities, how they solve these issues in different jurisdictions. I would try to move quickly to the improvement issues. I mean the improvement into the Russian legislation. From a point of view of, from the market perspective, nothing's working. Slides are not switching.
По-моему, не работает вот это.
It doesn't work, I guess.
Я хотел бы отметить, что
I would like to say that M&A of public companies
все более важную
occupies
практике
a big share in the Russian M&A practice, legal practice. As you see from this slide, recently the volume of these deals exceeded 50 billion USD, especially in 2011. These statistics show both public and private transactions, but public transactions have the bigger part because they have bigger amount.
Может быть, вы будете переключать нас
May-
на следующий слайд.
Next slide, please.
Слушали, пока у нас работает.
Doesn't work.
Можете переключить? Просто, да, спасибо. Вот,
Thank you.
основные способы
So the main
вам хорошо известны.
options of public M&A, it could be the acquisition of the control package, or reorganization or restructuring of the company in terms of merger or
Также возможно
acquisition, then voluntary
предложение о приобретении
offer to acquire
последствия
some shares to get the control, and then maybe the obligatory or mandatory offer. I would like to say that from the point of view of the main trends in this market, it's quite natural. Some transactions are structured as the acquisition of the controlling package because of the Russian legislation, because many Russian companies have controlling shareholder. Recently, we see the growing number of reorganization option. Till 2010, 2011, we practically didn't see this type of transactions. These transactions are done in accordance to the Russian law, a law on the shareholding companies, and it allows to use Russian shares as a method of payment to get some assets in this company. Taking into account the economic situation, financial crisis, these transactions became more interesting in the field of public M&A because they allow to use not just the money but just shares. Among these transactions, you see Uralkali, Sylvinit, ATS, acquisition, creation of the Russian stock exchange, Wimbledon, purchase of Wimbledon, Kalin. The specificity of this transaction is that these transactions, despite that the fundamental or basic transactions are done in accordance with the Russian law, we manage to apply to some extent the possibilities provided by the foreign legislation, and some transactions were governed by the foreign legislation in order to reinforce the structure of these transactions. This is very interesting because sometimes you should combine both the best of the Russian legislation and something from the foreign legislation in regarding those aspects which are not covered by the Russian legislation in this regard. I would like to say that in the public M&A transaction, the main factor is the fulfillment of the corporate management requirement and protection of the minority shareholders' interests. transaction with Uralkali Silvinit, all shareholders were on an equal footing, be it a big one or a small one, and the best practices of the corporate management or governance were fulfilled. Russian companies start applying the best corporate practices even in those circumstances, which is when it's not required by the Russian legislation. First, it demonstrates that we need to apply these practices already now, and secondly, the Russian legal practice should be improved in order to use these practices, or at least should be mandatory in order to get some benefits in the processes of mitigations of risks of dispute. And I would like to dwell on such a notion as the independent directors or committee. Some practices require to set up these committees of independent directors when there could be a direct or indirect conflict of interest. For example, the transactions or deals with the shareholders, which could be related with the interest of the directors. In some countries, like in Great Britain, there is such a practice when the control on definition of the terms of this transaction is done by the Committee of Independent Directors, which can ensure the protection of interest of minority shareholders and transparency of all the procedures. As a result of this work, we can develop the structure of this transaction in order to protect the interest of minority shareholders, which is a fair thing, and in those countries which these committees are widely used, it could reduce the risk of dispute or challenging of this transaction, because it would be very hard for the court to say that this transaction was unfair in terms of minority shareholders. By the way, I would like to say that the Russian companies can use this mechanism of independent directors. It could be set up by the board of directors, establish the budget and address all other issues, and provide recommendations for the board of directors whether to approve a transaction or not and on what conditions. The importance of this issue is that the independent directors can attract finance experts, consultant. They can create the conditions and structure of these transactions which could reflect the interest not only the bigger shareholders but all shareholders in this process. The Russian companies they use the special committees on several occasions. Citronics company last year considered an issue of the voluntary offer by the controlling shareholder to purchase practically all shares in free circulation. The conditions of this voluntary offer were considered by this committee. The same by MTS company to purchase MGTS shares, and recently the purchase of acquisition of 20% of Gazprombank and Wimpelcom before it became a Dutch company used this committee as well. I would like to say that it's not required by the Russian legislation, and so far it's not known to what extent the Russian courts would take into account the interest of these committees. First of all, but still it can mitigate the risk beyond the Russian jurisdiction, and we would like to see these changes in the Russian legislation, and the courts should when we expanded the rights of the minority shareholders, but we failed to create some mechanism to protect the interests of the companies against the hostile acquisitions and other hostile activities, which not in consistency with the international practice. Here you see the examples of the legal practice in the United States. And I believe that in Russian legislation we need to pay attention to creating possibilities for the companies to be protected against hostile acquisitions or other hostile activities violating the interest of all shareholders in the United States. Quite evident example, the poisonous pile. This is a mechanism to protect the interest of the companies when shareholders have the right to acquire. The proportionate number of shareholders at the price lower as the market price. If they see that hostile shareholders is trying to purchase or acquire the package, maybe 15-20% of shareholders without the consent of the board of directors of this company. So if you see the accumulation of this package by the hostile shareholders, then the rest of the shareholders can get the right to increase their share at the price which is considerably lower as the market price. The advantage of this mechanism, it allows the management of this company to counterbalance in negotiations with these hostile shareholders. Academic reviews have shown that those companies which have this mechanism, they can get higher bonuses in acquiring the controlling package. So all shareholders of this company can get additional benefits. In the United States, this mechanism is governed by the court practice, and it's not allowed in all states because it's not universally acceptable in the United States.
The United States have other remedies from hostile takeovers. Like, for instance, you cannot replace the entire board of directors at once. You can only replace 1/3 in 12 months. So the acquirer cannot obtain full control of the company at once, but rather the acquirer will have a longer period, allowing other parties to defend their interests. Then limited opportunity to convene extraordinary general meetings of shareholders. Only in Russia you can have it once every 3 months without any consequences. This is a fairly costly process for major companies and distracts management and is an effective green mail method. It should be noted that minority shareholders in Russia already have the opportunity to influence companies via electing directors to the board of directors using cumulative voting. It is surprising that we have this in the law. There's none such thing is in the UK. Well, in the state of Delaware is also possible, but is not a norm elsewhere. Like, for instance, if you take major American corporations, part of S&P, only 10% of these companies make it possible for shareholders to undertake cumulative voting. But the situation here in this country is that as you're influence without making any proposal to the minority shareholders about buyout. So there's room for additional thought about what to do in this situation, because there's more and more public companies playing greater role in the economy, so we got to think about how these companies can protect themselves, defend themselves from hostile takeovers, and what tools they have to interact with the shareholders. And in general, we need to continue the overall trend to protect the minority shareholders, inter alia creating incentives for companies to follow best practices in corporate governance. Thank you.
I think this area in particular, such kind of defense mechanism under public takeover law would be worth being intensified in a separate session, so maybe next year then. So I would then now hand over to our last speaker, which is Valery, and the topic of his speech will be analyzes ugolovno pravovih riskov fraziskih сделках M&A как новая тенденция. Пожалуйста.
Добрый день, уважаемые коллеги.
Good afternoon. I'm Valery Zinchenko. I'm a lawyer, senior partner in Pen and Paper. After Alan told us about the golden pill, no, I'm sorry, the poison pill, it is high time to talk about criminal law. To begin with, in the beginning of the 21st century, a lot of strong players came to Russia, not just football players, soccer players, but people now do understand what is a classical M&A deal in the classical understanding, Western understanding of this concept. And Western colleagues have helped us, and once they came, it has become a fashion to do M&A deals here. Russian consultants have now learned to undertake, perform, structure, and close M&A deals. And the Russian business, having defended itself, has become wiser and more civilized. Ironically, with the Western legal culture, Russia was supposed to get closer to international standards. If it wasn't for one thing, criminal risks in Russian M&A transactions. I believe that such criminal risks can stem from the lack of good faith of some of the parties, or lack of attention. Well, I will not talk a lot about ill intent, but still some ill in law enforcement. Buy 50% of the shares in the company, and let me note that in addition to our client, other shareholders had also title to the buildings with construction progress. Well, due diligence was done. We were asked to look at the criminal risks only. We've looked at them and we found some. As a matter of fact, our investor was offered to take a stake in the company and make a decision with the other investors to separate a new company from the old legal entity for the new investor to be able to painlessly continue with its business, build business, and they said there will be no problem with the shareholders of the old legal entity, and all the problems would stay with the old legal entity. We thought the risks were significant, and we tried to put the hat of the law enforcers who could try to protect one of the shareholders, who could think that this separation of the companies violated their interests. This is how it could look like, and I'm quoting literally. At this point in time, under these circumstances, the client, as a officer of a commercial entity, defending his own interests, and had an intent to cause damage to individuals, has set up an organized criminal group, as a result of which, by bringing in several individuals, distributed criminal roles among them and discussed the remuneration of each participant of this criminal group. After which, according to this allocation of criminal roles, he instructed to make a decision to reorganize the entity by separating it into two companies. And the objective was to cause financial damage and stole funds, damaging other organizations and individuals. That is, committed a crime according to Article so-and-so of the Criminal Code of the Russian Federation. Agencies, because paraphrasing a Russian writer, I would not recommend to write these things before a good lunch, or you can lose your appetite. It could be like a poison pill. Let me just say that not always, fortunately, in Russia, criminal risks end up with criminal cases, or criminal prosecution, or a court ruling, but a client, sometimes it's sufficient just for a client to be invited for a conversation, by the law enforcement agencies, so that they forget forever about any possibility of criminal risks. So I'm not sure about a rating of an article of the criminal code that could be used here. Well, number one would be fraud, if we rated these risks. Number two is damage by deceit. Number three is abuse of authority. Number four is intended bankruptcy. And number five is malintentions in bankruptcy. I'm totally sure that these risks should be thought about in advance, because the partners in a deal can agree on the distribution of economic risks, but nothing will protect them from the government, whether it's right or not. And I'm sure that an analysis of such criminal risks should not be viewed as a possible additional option for M&A deals. I believe that this is an area to focus on with particular care. And I hope that soon the analysis of criminal risks in M&A deals will grow from a trend into routine, daily legal work. Dear colleagues, thank you for your attention. Thank you.
Larry? So this was the last part of our session, and I think as M&A lawyers we take this seriously and should always avoid any such criminal risks as you explained. So thanks a lot for your attention.
Thank you for your attention and participation. Wish you enjoy your stay in St. Petersburg and enjoy the forum. We'll be glad to see you next year. Thank you very much.